Hello, everyone. Welcome to Investment Immigration Conversations. I'm Carolyn Lee, principal and founder of Carolyn Lee Pllc, an investment immigration law firm dedicated to helping clients build their futures with investment immigration. Today, we'll be talking about lawful source of funds for EB-5 investment. And there's a lot to say here, as you can imagine. So we're going to, let's say, start the conversation about it, particularly in light of a couple of new rules relevant to EB-5 lawful source of funds under the EB-5 Reform and Integrity Act of 2022. But first, a little announcement. There will be a USCIS EB-5 stakeholder call held October 19th at 2 p.m. Eastern. And we will, we have posted some information about this on our website, carolynleepllc.com. And the service is soliciting comments in advance. So if you have questions or comments for USCIS on the EB-5 program, you are invited to write in comments. And at this session, the service will give an update on program and presumably on EB-5 RIA implementation, and also take some questions from the floor, their usual format. So let's start our conversation about EB-5 lawful source of funds. And my goal is to, as I said, start the conversation and introduce some of the new concepts in the RIA about EB-5 lawful source of funds, but also share with you my approach in analyzing and in documenting, in reviewing, in encountering a client's lawful source of funds. So hopefully that will be interesting as well. So first, lawful source of funds, the new requirements, and they are found in subparagraph L, 203B5 new subparagraph L for lawful source of funds. And I'm going to start by reading the language because I think it's helpful and it's not that long. The statute now reads, an alien investor shall demonstrate that the capital required under subparagraph A, that's the subparagraph that states the new minimum investment amount, and any funds used to pay administrative costs associated with the alien's investment, fees and costs associated with the alien's investment were obtained from lawful source and through lawful means. So right away, we have some new concepts here. We always had to source the funds for the EB-5 investment. But now we need to also add to that a sourcing of the administrative fees and costs associated with the investment. So backing up just a little bit to the amount that we need to account for. It is $800,000 at the investment level, at the capital contribution level for investments in rural areas, high unemployment areas, and in infrastructure projects. And for all other projects, the new statutory amount is 1.05 million. So now, on top of that base statutory amount is the requirement that we lawfully source, or the investor lawfully source, the administrative fees and costs associated with that. And when you look at the new I-526E form, you will see that there is a box with rows that are designed to capture the investment amounts and the dates that those investment amounts went into the new commercial enterprise. We're talking about the capital contribution, the minimum statutory amount. And then there is a separate area on the I-526E form that's capturing the administrative fees and costs associated with the investment. So this is, so we're not only documenting now the lawful source of the administrative fees and costs, but it's also being captured on the new I-526E form. And of course, the I-526E is a new form that USCIS has published to implement the Reform and Integrity Act. The E form, the 526E, must be filed by investors whose investments are associated with regional centers. For investors filing under the direct program, not affiliated with regional centers, the form is the I-526. What are some of the highlights of the new requirements? Now, this isn't a game-changing, universe-changing landscape that we have with respect to the lawful source of funds here under the RIA. Unlike the regional center administrative oversight and integrity regime, which is very different. There's a very thick overlay of oversight and administrative responsibilities for regional centers, very much designed to be so under the RIA. The lawful source of funds provision is not intended to affect that kind of change to the EB-5 program. But there are some highlights. The addition of the administrative costs and fees to the lawful sourcing requirement is one. Another is this concept that to the extent that tax returns, personal and or business, are relevant to the lawful source of funds, the look-back period is 7 years. So I think that the natural question that this would evoke is, well, what if we don't have tax returns in our jurisdiction, or they're not required to be filed? Then they may not be relevant, or they're not available. And I think that a statement to that effect would be helpful to the examiner. What if I have less than 7 years tax returns, but tax returns are available? Then I think that it would be appropriate to talk about, well, why isn't there? And depending on the reason and the context, that may be worth a mention or possibly some amplified discussion in the lawful source of funds documentation as well. But the point here is that the look-back period for relevant tax returns, personal and business, is now 7 years. There's also this concept of the identity of all persons who transfer funds to the U.S. on behalf of the investor, requiring identification in the filing. So, and this might be, this isn't new perhaps to practitioners and to advisors of investors when there are exchangers of currency involved, typically documenting the identity of the exchangers, whether they're individuals or a business, would be a part of source of funds documentation or path of funds documentation, even pre-RIA. Now, though, this is an express statutory requirement, so that's got to get in there. There's also express mention of gifts that is also new. And I think in terms of documenting lawful source of funds where there is a gift component, either partially or in part. And this is very, very common, right? There could be gifts from your parent, an investor's parent, or both parents, or a grandparent, a relative. There are also instances of gifts from family friends. And the statute now says expressly, look, if your lawful source of funds involve a gift, two key concepts. One, the gift can't be put in place to obviate a requirement that your source of funds must be lawful. It can't be an obviation or circumvention of lawful source of funds requirements or any other laws. And secondly, to the extent that we're talking about documenting and presenting evidence of lawful source of funds, those documents must refer to the donor, and the donor's source of funds of the gift being from lawful sources. Now, this is common sense, I would posit, and that it's general practice, and it has been general practice, to pierce through the investor to the donor where there's a gift involved, and making sure that there's documentation of that donor's source of the gift. But it is now an express requirement under the statute. And I think that gifts will come more to the fore, perhaps, under the Reform and Integrity Act than even before. And there were fairly prominent transactions before the RIA. And I do predict that it may be more prominent or prevalent in the post-RIA world, because we now have concurrent filings. And now this is a big boon, big legitimate boon that the RIA has given the EB-5 community, the investor community. It's the ability for investors with immediate visa availability. That means that their priority dates are current, or the entire category is current for nationals from that country under the visa bulletin. If you have, as an investor, immediate visa availability, and you are in the United States and adjustable under the law of adjustment, then you may concurrently file adjustment of status with the I-526 or I-526E petition. So that would capture students, all those wonderfully lucky students studying in the United States who are able to apply for an EB-5 visa. Those funds are typically going to be from a parent or a relative, or as mentioned, a family friend perhaps. And so this looking through and capturing the donor's lawful source of funds is going to, I think, possibly be a little bit more prevalent in our new post-RIA world. Now, I wanted to share a bit about my approach to lawful source of funds review and analysis, and my interaction with these very important set of facts and the client and or the donor. And that's very often a part of my practice, is communicating closely with the donor involved in the EB-5 investment, often a parent. My first way of approaching the lawful source of funds is looking at the facts from a narrative perspective. And that is the word that I've used from the very first, now nearly 20 years ago. Always sought to find the story. What is the narrative? How did this investment source, these funds, the wealth in some instances, come into being and in a flow historically, whether that's a short span of time dating back to a transaction of months ago, or whether it is generational wealth accumulated and or passed down over generations. There's a story there. And I've seen what I do as finding that story, that through line, and then tracing that story, the key markers or milestones or stops in that narrative, in that journey, in that story, and writing that narrative and finding the evidence that is most relevant to tell that story in a way that makes sense. And flushing out that narrative and supporting that narrative with evidence that makes sense in that story, in that narrative to bring out. And in that exercise, it's very easy to put myself in the place of the examiner, USCIS examiner evaluating the lawful source of funds. He or she will want to understand that story. Where did this investment come from? That is the question. And so if I can view these facts that I know the examiner is very interested in that way, view it myself in that way as a narrative, and present the evidence that I know that reasonable adjudicator is going to want to see, is going to look for, then that makes my conversations with my client or the donor that much more sensible, really. It makes sense. It makes sense for us to have these conversations, to ask, do you have this bit of evidence that I think would make sense in this story? Sometimes those key bits of evidence that I think will really highlight and bring that story to life are not available. And in that instance, we have to look at, well, does it make sense still to work with this narrative? Is it that important? Is it going to raise such serious doubts without those key bits of evidence that we really need to change our approach and look for an alternate narrative, alternate source of the investment? And this is another point. It's important to work with you, the investor, the client, at a stage before there is a commitment of the funds, because then that is where we get to work together and explore what is the narrative here. And can we support this narrative with that evidence that we know that reasonable examiner is going to be looking for? And if it isn't, then we're going to have to think and talk about alternative narratives, alternative evidence. Whereas if and we of course have worked in these situations as well, where we have the funds already having been committed or transferred. Sometimes we can still make that work with the understanding that there might still be some weak spots here, and those weak spots may be fleshed out later in a request for evidence. And so anticipating that, we've got to be ready for it and talk about the evidence that we would have to submit if those questions were to arise later on, and understanding that that later point in time can be a couple of years from now. So this is about anticipation, and this is about informing the investor, you, the client, about what could happen down the road in the lifespan of this case. So sometimes it's about rehabilitating the narrative after the fact and exploring the evidence. If it's not the best evidence available, is there second best? Are there alternatives? Okay. Other times, and this happens very rarely, but it can happen, where it is, in my view, it's not worth finding out 2 or 3 years from now that this narrative didn't work and that we can't overcome a request for evidence or worse in the life of this case. And so there is the odd, I would say, maybe 1 in 1,000, 1 in 1,000 plus, at least that's been my experience, where the wire has to be reversed. No one likes that, least of all the enterprise. But to avoid that happening, we want to work with you before there's a commitment of the funds. And I call it green lighting. We want to get to a place where we can green light the wire so the transfer or the transfers to the new commercial enterprise can happen after that conversation and the review, the document review has happened to a satisfactory level. I think it's worth also touching at this point. Well, what is that satisfactory level? What is that satisfactory level for me as an attorney? I will say that I have held myself, my clients, and the case to a very high bar. I will say that. And I will also add that I don't think it's always been viewed as entirely welcome. And, you know, I've heard comments like, well, it's good enough. And it's, it'll pass muster. And that ultimately, that is the goal. We want to get to the finish line. But the finish line isn't just the 526 approval, obviously critically important. The finish line is 829 approval. And I want to talk about that and lawful source of funds in just a minute. But I'm talking about my own standards. For me, good enough is not good enough. If good enough means likely to pass USCIS muster and no more than that, I can see the reason in that, but that is not enough. I have to be confident that regardless of whether or not we get questions on the lawful source of funds, that I know that we can respond to it and overcome reasonable questions. Now, there have been instances, not many, but there have been instances where cases were filed, had to be filed at the client's request and urging to meet a deadline, for example, where I have known that there are issues that we can get a request for evidence or worse on. At all costs, I try to avoid filing a case that raises serious issues of approvability on the facts, meaning not just that we might get a question about it and it relates to an event from 5, even 10 years ago. And I know that we'll be able to respond to that on the facts, on the historical facts, and be able to overcome, have arguments to overcome, have facts to overcome. There are instances, I believe, where the facts aren't there to be overcome. And now that's a very, very hard situation that I do believe there's very frank conversation. And it would go something like, there are such serious flaws or a flaw in this case that anticipate the reasonable examiner to question, to identify that flaw or flaws, and it may not be overcome. And are you, client, prepared for that? Because that's what filing this case in this moment would entail. And then I can see the client saying, yes, I get the risks, let's do it anyway. Or the client saying, you know what, It's too much. It's an at-risk investment. If the case is denied because we can't overcome the questions, I may not be able to get my funds back. It's not worth it. Very reasonable. So these are the kinds of conversations that an in-depth analysis of the lawful source of funds that I believe is necessary, particularly in the new RIA world, Reform and Integrity Act, that I think we need in the EB-5 cases of today. Now, why? Because I've seen exactly why. Not only do we assume that this is what the examiners are looking for in the post-RIA regime, I think that's a very safe assumption. But even for cases filed years ago, a decade ago, I report to you that I am seeing I-829 RFEs, requests for evidence, notice of intent to deny, NOIDs, and denials. 829. For those of you who don't know what that is, the I-829 petition is the very last stop on your EB-5 journey. You file the I-526, you establish eligibility for EB-5 classification with your lawful source of funds documentation and the job creation documentation, which in the case of regional center investments, the regional center will typically provide. Put those together, submit the 526E. Once that's approved, if you are still abroad and not eligible to adjust, then you go into immigrant visa processing through the State Department, culminating in an interview at the U.S. consular post in your jurisdiction. At that point, an immigrant visa issues. That visa at the interview, if all goes well, that visa will get placed in your passport valid for approximately 6 months for yourself and your qualifying derivative, spouse and children under 21. And then you come into the United States, and then you begin your 2 years of conditional residency. It's a green card, but with conditions. What are those conditions? The conditions are that your EB-5 investment must have created at least 10 full-time jobs for U.S. workers, and that you have kept your investment in as required under the law. And that showing to remove the conditions on your residency is made on the form I-829. Now, you can see that your 829 will have been filed years from when you first made your investment, from when you first filed your I-526, where the lawful source of funds was initially documented. 10 years from now, plus years from now, you will have lived in the United States, settled here, become a permanent resident with conditions. You may have had children here. Your children may go to school here. And then you get this nasty request for evidence or NOID that challenges your lawful source of funds from way back when. And so I can see that good enough sometimes is not good enough. There you have it. EB-5, lawful source of funds under the EB-5 Reform and Integrity Act. Oh, we have a question. I do regret that last time I had a webcast, we closed without taking any live questions. So we will take at least one this time. And so let's see here. Are personal loans based on credit worthiness without collateral from international banks permissible? Yes, they are. I would like to have conversation about this, though. And this was under a fairly recent court case where there was litigation against USCIS. It was determined that loans that are not secured can also qualify for EB-5 investment. And there's no preclusion. There's nothing that says you can't do that, reversing of that court decision in the RIA. That said, I think, again, we've got to be thinking, how can we establish the bona fides, the good faith, the legitimacy, the lawful source of funds of this EB-5 investment? So it has got to not only pass the smell test, but it's got to be bona fide, and it's got to perform that way. And so, if we're talking about this question specifically said from an international bank, if it's a financial institution, particularly one that is that's going to be recognizable, that is certainly going to help build the credibility of that aspect of the narrative. That is to be contrasted with a personal unsecured loan, same type of transaction, right? That's, from a friend. In theory, that same court decision would not preclude that transaction either. But I certainly would not green light, or we would have a lot of conversation about it. In other words, I'm not going to preclude that I can't envision a universe where a 2 to 3 page personal loan memorialization couldn't work, but we would certainly have a discussion about it. This webcast, the topic of this webcast was determined based on our survey of topics of interest to our audience. And you're invited to send us your lawful source of funds question or questions, and we will address them. And we'll also include a link to the stakeholder engagement for those folks who haven't yet seen that. And we will keep you informed and have additional EB-5 and investment immigration E2 related webcasts in the coming weeks. There's a lot to say, there's a lot to share. So stay tuned. Have a great rest of your day and evening.